and welcome to S&C's podcast series, S&C Critical Insights. I'm Ryne Miller. I'm a partner in our general practice group, and I'm here with Katy McArthur, my partner in our litigation group. Katy and I together co-head the firm's commodities, futures, and derivatives practice. And today we wanted to spend some time giving a quick update on a recent CFTC release from their Division of Enforcement. Specifically in May, the Division of Enforcement put out guidance on how they're going to approach civil monetary penalties and the different factors they're going to take into account. Katy, I know you're here as well. Can you talk us through what did they do? What did they put out? What's in there?
Sure, Ryne. The guidance that came out, it was released by the Division of Enforcement on the 28th of May, as you said. This is the first public guidance that we have seen from the CFTC regarding how civil monetary penalties are determined in connection with CFTC enforcement actions since 1994, when the CFTC first published a policy statement about civil monetary penalties in its cases. The guidance that came out is directed to the staff of the Division of Enforcement. It's binding on everyone within the Division of Enforcement, and it's been incorporated into the enforcement manual, which acts as sort of the bylaws and the rules of governance for personnel in the CFTC's Division of Enforcement. In the context of CFTC enforcement actions, the civil monetary penalty is the monetary component of a resolution that companies will pay. It's the equivalent of a civil fine, is one way to think about it. It's the civil penalty that ultimately gets paid by a company or individual that is resolving a case with the CFTC. And what this guidance does is to provide criteria for how staff in the Division of Enforcement are supposed to think about the right number to recommend to the Commission in connection with enforcement actions that the Commission may be pursuing.
Thanks, Katy. That's helpful. And one question I've got from a few corners is, why now? Why in May of 2020, when the CFTC has been bringing enforcement actions and settling enforcement actions since, you mentioned, 1994, when the original guidance was released, and before? And I think there's some observations that help add some clarity or at least some insight. First, the current leadership of the CFTC, and you have to go to the top, Chairman Heath Tarbert, has placed a huge emphasis on transparency, and not just transparency in the enforcement process, in the potential range or scope of enforcement resolutions, but across the CFTC's entire program. We're seeing this in the notice of proposed rulemakings. We're seeing this in the chairman's speeches, where he tries to preview his policy agendas, his goals, and his priorities, both on the rulemaking front and on the policy front, for whatever the next period of time is going to be. And so I think there, the Division of Enforcement and its director, Jamie McDonald, has taken the cue and said, understood, we want to be as transparent as possible. I mean, Director McDonald has always done this in his public speeches anyway, tried to provide as much guidance as he can to market participants with respect to his expectations on things like cooperation and how you interact with the division. And so here we see this idea of transparency resulting in a written piece of work product, updating something that yes, it did exist in 1994, but I think an active effort at transparency by the Commission in reminding folks that these policies are there, that they guide the Division of Enforcement, and in fact adding some additions and new pieces of information to the guidance, which Katy will walk us through a bit. One interesting fact to point out is Chairman Tarbert has encouraged the CFTC staff to sort of take ownership of different core values and their approach to regulation. And they put out their CFTC core values recently, and they're announced as commitment, forward-thinking, teamwork, and clarity. And of course, CFTC, matching the CFTC's letters. And so here again, another example of CFTC transparency. Moving to the guidance, Katy, what have they put in here? What's going to drive these considerations of civil monetary penalties?
Sure. So the guidance really centers on three categories of considerations that the enforcement staff are required now to consider and factor into their assessments of the right penalty to propose. The overarching principle here is to pursue what the division has defined as the dual goals of both specific and general deterrence. And that goes to the transparency point that you just raised. Obviously, enforcement actions will be more effective in deterring conduct if there is greater transparency and visibility to how resolutions are reached. As I said, the guidance focuses on three central categories of considerations. First, the gravity of the violation. Second, the mitigating and aggravating circumstances. And third, other considerations. And we'll walk through each of those in a little bit of detail. The first, relating to the gravity of the violation, is identified in the guidance as the primary consideration for determining an appropriate civil monetary penalty. And there are a number of factors that are listed in the guidance that the staff should consider as relevant to assessing the gravity of any particular violation. Those include things like the nature and scope of the violation. So, for example, how long the violation continued and across what time period, what was the breadth of conduct that was involved. Other factors include the respondent's role in the violation, whether the respondent acted in concert with others, whether there were any efforts to conceal the ongoing violation, and things of that nature, as well as things like whether the violation resulted in harm to victims, and if so, the number and type of victims that were affected. A second factor that's enumerated with respect to the gravity of the violation relates to the respondent's state of mind, including whether the violation was willful or intentional, as opposed to a result of inadvertent or unintentional conduct. And then the third relates to the nature and scope of consequences resulting from the violation. So things like a risk of harm to victims or market participants, any potential benefit to the respondent, as well as the impact on market integrity. All of these would be factors that would be considered in thinking about the gravity of the violation. And the guidance makes clear that none of those factors is meant to be dispositive, nor is that list of factors exhaustive, but all of them would be relevant to considering the right place for the civil monetary penalty to be proposed. Layered on top of that is a second category of factors that are considered relating to whether there were mitigating or aggravating circumstances. And the guidance does provide a list of what some examples of mitigating and aggravating circumstances might be. Importantly, on the mitigation side, the division has continued its focus on cooperation, self-reporting, and remediation, which are highlighted in the guidance. So some of the factors include, for example, whether the respondent self-reported the misconduct. Also considered the extent of cooperation and remediation, and the guidance makes reference to the division's various enforcement advisories around cooperation, which has been a central focus of the division in recent years. The mitigating factors also include a focus on the timeliness of the respondent's remediation. Was remediation undertaken, and how promptly did that remediation get done, as well as the existence and effectiveness of the company's pre-existing compliance program. And so we see here a continued focus on the existing compliance program that was in place at the time that the violation occurred. In terms of some of the aggravating factors or potentially aggravating circumstances that are identified in the guidance, there is a focus on post-violation conduct, potentially aggravating conduct if there are efforts to conceal or obstruct evidence in connection with an ongoing investigation. The guidance also identifies as an aggravating factor whether the respondent is a recidivist. And so a company that has faced CFTC enforcement actions in the past would be subject potentially to a higher civil monetary penalty in a future action simply by virtue of having had problems in the past. Additional aggravating factors include the pervasiveness of the misconduct within the company, including whether senior management or senior officials were involved or had responsibility for the violation, as well as the nature of any disciplinary action taken by the company with respect to the individuals engaged in the misconduct. And that's a factor that you could see being potentially a mitigating factor if handled correctly, and potentially an aggravating factor if the division staff believes that the steps taken by the company were not consistent with what they would expect of an effective compliance program. Finally, the third category of considerations is sort of a catch-all. It's defined as other considerations. And again, it's a non-exhaustive list, but among the things that the division are directed to consider include looking at sort of the big picture, the total mix of remedies and monetary relief that are to be imposed on the respondent in the recommended enforcement action, as well as the remedies and relief that will be imposed in any parallel cases that may involve criminal authorities, other regulatory entities, or self-regulatory organizations such as the exchanges or the SROs. Finally, in that regard of other considerations, there's a focus on whether there's monetary or non-monetary relief that's being provided in similar cases, as well as the use of commission resources, including timely settlement. And that last factor would seem to dictate that entering into a timely settlement, reaching an earlier resolution with the staff and allowing them to conserve resources on balance ought to weigh in favor of a lower civil monetary penalty. Ryne, maybe you could just speak for a moment to a question that I'm hearing a lot, which is how the marketplace and market participants should think about the interaction between the guidance that was issued by the Division of Enforcement and the earlier policy statement from the Commission itself back in 1994, whether one replaces the other and how they interact or overlap.
Sure. Thanks, Katy, and thanks for walking through the guidance itself. I think really helpful. So Jamie McDonald, the Division of Enforcement Director, has made some public comments on this, and he clarified. He said this guidance is a supplement to, and it's not a replacement of, the 1994 policy. And I think that's a helpful comment because, like I mentioned earlier in the podcast, we've been resolving enforcement actions with the CFTC before and since 1994, and there is some idea through the policy of how the CFTC approaches calculation of monetary penalties. It is helpful to hear from the enforcement director that this is a supplement and not a replacement of the prior policy. Some interesting supplements that we can objectively identify looking at the guidance. The reference to parallel criminal sanctions, for example, a parallel DOJ case and resolution, was not part of the 1994 policy, and now it's expressly something that Division of Enforcement staff are directed to consider when they reach a settlement. In addition to parallel criminal sanctions or criminal actions, the idea of deterrence, or the word or concept deterrence, was not a major focus of the 1994 policy, whereas with the current guidance, deterrence and specific and general deterrence are expressed focuses of the goals of the Enforcement Division in carrying out the guidance. Lastly, looking also back at the 1994 policy statement, mitigating and aggravating circumstances were not identified as relevant considerations. In the new guidance, as Katy summarized before, they are relevant considerations, and the staff is directed to consider those. And so I think what we have in the guidance obviously is not a matrix or a clear objective calculation tool to get to a penalty, but it gives us a more clear and thorough outline of the different considerations and factors that enforcement is going to think about in proposing resolutions and negotiating resolutions. I think with that, Katy, what do we say are the implications of this going forward, for defense counsel, for entities undergoing investigations?
Yeah, it's a good question, Ryne, and obviously something that a lot of us are thinking about. I think there are a few key takeaways that we can draw. The first is that although the 1994 policy guidance hasn't been supplanted, and that still applies to how the Commission will make decisions, for defense counsel who are engaging with staff in the Division of Enforcement, it's obviously important to bear in mind that the staff are going to be referring primarily to the guidance. That's what binds their recommendations up to the Commission. And so defense counsel will need to consult the new guidance and refer to it in their dialogue with the staff in thinking about appropriate penalties in connection with pending cases. I think one potential outcome of having clearer and more detailed CNP guidance that enumerates factors, I guess, in a bit more detail, certainly one outcome that I think we would hope to see as a result of the new guidance would be a greater uniformity and consistency across civil monetary penalties in connection with CFTC enforcement actions. That's one of the stated objectives of the guidance, and I think it is a hope that we would see with respect to having more detailed guidance available. In addition, I think market participants can expect that there may be greater consideration given to the piling on potential effect of having parallel proceedings between the CFTC and the DOJ. We have seen increasingly over the last few years, there certainly is a trend of the CFTC and the DOJ pursuing their own actions. The DOJ has explicit guidance and a policy statement against piling on and is required to think about its penalties and how they line up with penalties that may be imposed in the civil context. And I think the new guidance from the CFTC Division of Enforcement specifically identifies the total mix of remedies and monetary relief imposed as one relevant consideration in the potential CMP. And so they think that leaves room for consideration by the staff of how penalties imposed by other authorities, including criminal authorities or potentially other civil authorities, how those should factor into the overall mix. And we've heard in public remarks from the Director of Enforcement the fact that the Division of Enforcement considers a DOJ resolution and the impact of that resolution as it thinks about the appropriate civil monetary penalty in a CFTC case. Finally, I think it's important to note that the guidance does specifically refer to deterrence as an overarching consideration in the determination of civil monetary penalty. It refers to both specific and general deterrence, and I think there remains quite a bit of uncertainty as to exactly what that means in the context of arriving at civil monetary penalties and whether we can expect to see any shift in terms of the approach.
Thanks, Katy. I think that's all very helpful. And the guidance itself is a move forward. It provides the framework, it provides some clarity, and it provides several points of discussion with the enforcement staff as these conversations around resolution take place. That wraps us up for today. Thanks, everyone, for listening to S&C Critical Insights. For more information about our practice, please feel free to visit us on the web at www.solcrom.com.